Шановні учасники конференції, вельмишановні спікери і всі.
So dear participants, dear speakers, all those whom we are waiting, we are ready to start the next panel discussion. I still give you a little bit of time. I just want to remind you that you may read the summary using the QR code in your badges. In the end of the text, we have this signed communique link. So if you support the idea, you can leave your signature under the document. Also, I'd like to draw your attention to me, to the stage, and express gratitude thanks to your applause. Okay, let us just focus right now on what's going to happen. The gratitude to organizers and partners. First of all, Ukrainian NGO Tribunal. Justice for Ukraine and also our strategic partner, Toronto Kyiv. Media partner, legal practice. And also the loudest applause for our defenders. For our defenders. They are standing there defending us, paying the highest price today. So, the topic of the third panel, procedural aspects of international criminal tribunals. How to conduct a trial. Yeah, the key question. What should be there in the process? Okay, we'll talk. But in this panel, who will moderate the discussion? Minister of Justice of Ukraine, Denis Maliuska, and a round of applause. We already prepared in advance, but everything I have, I still have a list of your colleagues. I still have to, I have a list of panelists.
We would love to have here on the stage Gabija Grigaitė-Daugirdė, Vice Minister of Justice of Lithuania. Mathilde Professor of Public Law at Université Moulin, Lyon. We will welcome Oksana Zolotaryova, Director of the Department of International Law, MFA of Ukraine. A big round of applause to Oksana Blazhivska, member of the High Council of Justice. And Iryna Mudra, Deputy Minister of Justice of Ukraine. Як же згодилося із
Okay, so just as we had in the previous discussions, we also have some online speakers.
Online speakers, David Scheffer, American lawyer and diplomat who served as the first United States ambassador at large for war crimes issues, as well as Jennifer Trahan, clinical professor at New York University Center for Global Affairs and director of their concentration in international law and human rights. Please welcome. Stefan Hobe, professor, director of the Institute of Air Law, Space Law and Cyber Law, as well as co-director of the International Investment Law Center, Cologne. And please meet Egils Levits, Latvian politician, lawyer, political scientist, and jurist who served as the 10th president of Latvia. Pane Denis.
Denis, dear speakers. So please, thank you so much. Thank you so much. And dear guests, dear colleagues and panelists, I'm so happy to greet you all at this wonderful event today. Panel is really complicated, first of all, because it's after lunch. I do hope you all had a lot, because you can't sleep here in this room. Yeah, because we will try to keep you concentrated, make it interesting, but after lunch, it's better not to be part of it. Okay, so just a small introduction to our panel. You know, this joke about the wise owl. Mice asked him how to do it for no one to eat them in the forest, because everyone is trying to eat the mice, hunting them. He says, okay, mice, you have to become hedgehogs. They were so happy, but then returned asking they all how to become hedgehogs. I'm a strategist, not a tactic expert. I just give you the vision. So our panel is about tactics. So the previous panels were strategic, yeah, with a vision. How to create. How to work with immunity. We will stick to technical details. How to do the job. All right, the most interesting part, I'm putting the intrigue here, okay, but coming back to discussion. So, the correct tribunal, how is it different from the reality show, okay? What is the difference? It's about the procedure. If we take the Nuremberg trial, Nuremberg tribunal, this is a cool thing. With the exception that from the standpoint of modern standards of court proceedings, there were all possible like violations of standards, how to prove the independent accusation. So with the modern standards, it was more like a show, but not a tribunal. Yeah, maybe I'm exaggerating a little bit, of course, but yeah. One of the possible aspects for the tribunal decision to be recognized and taken seriously, for no one to say this is just a political show, we have to stick to the process and some proper international standards. So we will try to talk to our panelists about that. Me as a person who never established any tribunal, but I read a lot. You know, I watched a lot of documentaries. Not so many people establish tribunals in the world. Unfortunately, we will be one of them. I mean, the country. Just a couple of questions, important questions. And our panelists maybe will make a decision how it is better for them. Which aspect they will reveal. I will not force you, but a couple of key issues. All lawyers are interested in first. Is it possible to have a tribunal with the absence of the accused person? We understand that Putin, well, holding Putin accountable in Hague, in Bucha, in any other place where the tribunal will be located, it will be hard. Maybe initially even impossible, okay? So should we postpone the tribunal? Or we have to start without him? Or concentrate on collecting the evidence, or later to come to the trial itself. What should we do with it? Okay, question number 2. How should we establish the tribunal itself? Who will be the judges? Who will be the prosecutor? Who will assign them? What will be the selection process later to avoid any accusations that this is not integral and objective like it was in Nuremberg, where there was obvious tribunal of winners against the defeated ones, okay, with all the negative consequences, okay, when it comes to perception of the lawyers community. These are 2 big questions. The details of the process, it's not something new. We have a lot of institutional tribunals, permanent one. The ad hoc tribunals are there in Cambodia, Sierra Leone, and former Yugoslavia. All these are functioning with certain procedures applied. So, and I don't think that there will be so many problems with the procedure. Maybe the panelists know more. Maybe I'm mistaken. Maybe there are some nuances we have to take into consideration. So this is all with my introductory word. We come to details because the devil is in the details. Devil is always an interesting thing to me. Okay, we'll start with Vice Minister of Justice of Lithuania, Ms. Gabija. And we will take turns. Offline, online, you know, for online people not to fall asleep there, you know, after lunch, and for them to stay, you know, active. Okay, thank you. Thank you so much.
Dennis, and first of all, I would like to use this opportunity to thank for organizing such a wonderful and very, very important event, and event in Kiev. And I think every one of us from the very start of the first panel is enjoying it that much that I always wrote half of my book here. But I would like to start from what is written on all the materials of the conference, is that justice to be served. And if you put it in the Google, I did it just in the morning, so that means proper punishment and fair treatment. So what do we, just a little bit touching on the strategy and then going back to the tactics. So what about this proper mechanism? I think that decision, what is important to bear in mind is that decision on the modality that is going to be will have crucial importance on the legitimacy of Putin being still in power. Because there are still countries that are eager to meet him. There are still people that are eager to take pictures with him. And if you understand that this is permanent member of the UN Security Council, so, and he has, you know, being prosecuted for the crime of aggression, so that is very important, that as soon as we have arrest warrant, legitimacy of such person is being really, really undermined. And of course, you know, I get questions like, why do you need another arrest warrant? Because you have an arrest warrant from the ICC. It is needed, and why ICC is not enough? Because atrocity crimes, they do not require very difficult political judgments. They do not require for other states to make the decision that Putin has to be prosecuted for the crime of aggression. And here we have to have understanding that political judgment of all the countries is crucial here. We cannot stay neutral, and all the states have to have legal opinion on the model that we choose. And let's hope that the choice will be international tribunal. So now coming to the fair treatment and touching a little bit on the immunities issue. You know, I know that for the Nuremberg trial, the last panel will be devoted. But just coming back to what former US Supreme Court Justice Robert Jackson wrote to, at that time, President of the United States, he wrote that we do not accept the paradox that legal responsibility should be the least where the power is the greatest. So fair treatment for Putin this time would be to apply no immunities and to send the clear message to him and all the future aggressors that even you are in the power, even you have control still, you cannot do the things that you did. So that is a little bit on what justice to be served means. Now coming to the questions raised by the minister. I think the most difficult or the most discussed question is, of course, trials in absentia. And sometimes, you know, in the discussions among politicians and you know, policymakers and lawyers, of course, the question is raised like, does it have to be justified or done if in the end the judgment could not be enforced? And I always say that I personally would suggest looking at this possibility as part of the whole accountability process for the crime of aggression. And trial in absentia as such can never be a goal in and of itself. And what I mean by this, I mean that this possibility of starting the trial without having Putin and his entourage in the custody has to be seen as alternative to having no trial at all. And when you understand that at least you have to try doing it, you have to do it. And of course you have to, I mean, because we understand, I mean, the other panelists maybe will touch in more details that trials in absentia, they are not prohibited in international law. If you meet certain human rights standards like retrial and, you know, having knowledge that you are being prosecuted, then you can go for it. And I mean, that is the possibility that should not be sacrificed, because when we start, discussing about certain political or legal circumstances, then we have good international law principle that we immediately sacrifice for certain other policy-making goals that we might have. So I think that in search of this maximum legitimacy, we should not, concentrate on the circumstances that would lead to, justice being delayed or being that we have to wait for some other events to happen. Because, of course, the argument is that, the essence of international criminal law that is against, trials in absentia is like this accountability. I mean, that it is, effective and you have a person. But this is only, one flower in the bigger bouquet, because we have to care about the justice to victims, and I'm sure that Professor will talk about it more. Like, we have to understand that this is historical. We are standing at the historical moment. We have the first time crime of aggression being and needed to be prosecuted at that level, because, I think that it is as manifest as it can be. So we have to make sure that we manage to accept this very serious responsibility, and we just do it. Because fighting impunity, and the first panel was very clear about it, that if you do not fight the evil when it is happening, the evil is growing. So I think that if we leave it for the future, then we send very bad messages to the future aggressors and to the one that is on our attention table today. So I would say that trial in absentia should start, and then we should, work continuously to get the persons into the custody, because one or the other model is chosen, even though my preference is always on the international one. This cooperation and long-term planning with the states will be of crucial importance to get a person in custody. And people make mistakes. Maybe Putin now is learning by heart, 123 states, to the Rome Statute, but people do make mistakes, and you can never know, that sometimes circumstances can, fall in, and you just have a situation where you will have him. But of course, fairness, and I think it's about the procedure that we should talk a little bit more, is very important for legitimacy, as you say, because the development of the human rights framework that we have already from the Nuremberg demands us being very attentive and being cautious with the decisions that we make. But having no person is not a reason not to do it. But of course, big expertise, I would say, will be needed to make sure that we have a truly genuine adjudication. And we have lessons, because if you take, for example, criminal tribunal for former Yugoslavia, they did have solutions when they could not implement arrest warrant. They did public hearings of the evidence, so that victims, they at least partially can feel the justice is coming. So there are mechanisms, there are solutions, and I think that, with that nice, young audience, with that, outstanding experts that we have in all the panels, it's not a challenging task, What is needed is, more courage and political will. So now just a little bit stopping on the credibility of evidence, because I think it is important for me to talk about it, because, and it is related to the trials in absentia also, because, I don't know how many of you know Antonio Cassese, international public law scholar, and one argument that he uses so that he thinks that participation of the accused is, indispensable to make sure that you have a fairness of the proceedings, he said that usually the problem is that you cannot make sure that you have independent international investigation of international crime. But in this case, we have a center that has been established by JIT members, the center that has competencies, being offered by international institutions like, Eurojust. And with this, we can make sure that the prosecution, the investigation that we have is based on the real, impartial and independent basis. And because evidence quality is very important, and coming back to the Justice Jackson that I quoted already, he said that for such incredible events, we have to have credible evidence. And memory fade away, people die, so answering back to the question of Minister, at this moment, we have to concentrate on evidence collection and to view it very, very seriously. And what I mean by very seriously is that, all the national jurisdictions that have started investigation into the crime of aggression, they have different rules. So the sooner we agree on the common standard for evidence, I talk about how do we use open source data, for example, because this war is unique because we have that much information on open sources. We have enormous information on Facebook, but we have to create credible mechanism how we validate those evidence, because sooner or later, those evidence will have to be transferred to the tribunal in any modality, chosen, or any modality we have political will to create. So we have to make sure, and I think good lessons from MH17 trial, where we had this specific procedure, how they take the evidence from the open source and they validate it. And that means that the state brings that evidence as its own, not like it received, from the other sources. And of course, formal and legal procedures, because if we think about confidentiality issues, how open we are with the defense, to give the materials that we have, because there will be a lot of sensitive materials. So this is hard choices that are still waiting. But I think, just coming back a little bit from what I started, from the strategic decisions, in everything that we do, we should not forget that international law is being created by states. And, states, they do have the right to change the rules that do not fit the situation anymore, to make sure that international law is being strengthened, but not weakened. And all is needed is political will, and we talked with colleagues, from Ukraine, that we have to keep working, we have to keep convincing, because we don't have international, legislator that would change the law for the states. States themselves and leaders of the state, they do have to find political will to make sure that international law, as it stands, and it will stand for future generations, is capable of coping with situations like the one we have now. And if political will is there, lawyers are the creatures that will always find the ways to make sure that this political solution is being implemented in the way that we have credible, we have international institution that is able to serve justice now, but not, when somebody leaves the office or when the better times come. So thank you.
Дякую, Габія.
Thank you. We shall continue with our debate. And since we've already mentioned MH17, in case of MH17, there was a trial in absentia, and I think we could run some parallels. In case of MH17 that was tried in the State Court of Hague, one of the defendants had a lawyer, and he was justified. The rest of the perpetrators were not using the lawyers, and as the result, they had some sentences. I'm not sure what was the kind of the true situation. I just want to say that the sentences in the trials in absentia can be different, and that was not a complete tribunal. That was a hybrid court when several countries have delegated their own jurisdiction for the court hearing in Hague to take place. And as I've already promised, let's try to have some conversation with our online panelists, and I would like to pass the floor to Egils Levits.
Please, if you are here, if you hear us, please join our discussion. The floor is yours.
Can you hear me? Hello?
Yeah. We hear you. We hear you well.
Yeah. Thank you for the organizing of this very important conference in due time. I think we all agree that such a tribunal is absolutely needed. It's a question, not a judicial question really, but a question of political will, of the political will of international community. And we should promote this political will in order to achieve justice and in order to strengthen international law and not to weaken international law. Because without reaction on legal level in international law, the international law will be weakened because it could be used as a precedent that aggression is possible and nothing happens. So I think it is a pressing need for such a tribunal. For certain reasons, it is not possible to have this trial before the International Criminal Court, and therefore the alternative is a special ad hoc tribunal. And you have already discussed that a real international tribunal is the best model, and far behind, the second best could be maybe the hybrid. But we should concentrate ourselves now in order to promote a real international tribunal. There are two main questions from procedural point of view. The first is already discussed by my colleague from Lithuania, trial in absentia. If we have to choose between trial in absentia and trial in presence of the accused person, of course, we should choose the trial in presence of the accused person. But if it is not possible, then also there are two alternatives: to do nothing and to wait, maybe for a very long time, or to organize a tribunal or a trial in absentia. In several countries, also in ordinary criminal cases, trials in absentia are possible. For example, in France, in Italy, and they have already very developed rules how to organize fair trial. I will stress fair trial in absentia. And we can also learn from these specific rules. Also, fair trial is possible also when the accused person is not present. But in this case, there are several reasons why such a tribunal in absentia of the main accused persons from Russia should be organized. Although the first reason is accountability. Holding a trial in absentia can be a symbolic gesture emphasizing the international community's commitment to international law, and that the acts of aggression or violation of international law is not allowed, do not go unpunished. I think it's a very, very important signal of strength of the international community, of the international law. The second reason is deterrence. Even if the accused aren't physically present, a trial and potential conviction could serve as a deterrent for future actions of such kind for future dictators and aggressive states. Also, it has a preventive effect. The third reason is also mentioned by my Lithuanian colleague, documenting evidence. As time passes, evidence can be lost, witnesses might become unavailable, and memories can fade, and therefore holding a trial, even in absentia, allows for the systematic documentation and presentation of evidence related to this alleged crime. The fourth reason is closure and justice for the victims. The Ukrainian citizens, particularly those directly affected by the conflict, by the war, might find some form of closure or validation in seeing that the alleged crimes are being formally addressed in a legal setting, even if the accused person is not physically present. I think this is a very important point, justice for the victims. In general, justice for the victims is a part of the philosophy of criminal law, and especially, of course, in this case. The fifth reason could be, maybe we should think about preventing of some kind of politicization of the process if the person is present. In the absence of the absence of accused might, in some ways, limit the trial from becoming a political spectacle when the person is sitting there, and allows us more to concentrate on the evidences, on the assessment of the evidences, and of the real legal issues. The sixth reason is legal precedent. International law is developing mostly on the basis of precedents. The Nuremberg Tribunal was the first precedent, and before that, it was maybe for some lawyers, narrow-thinking lawyers, not imaginable that such kind of tribunal could be established, because it never happened. Then, 45 years later, Yugoslavia Tribunal was established. It was different from the Nuremberg Tribunal, but it follows a certain path with certain differences, and so on and so on. And of course, now is a time for the new precedent, and therefore the argument that such kind of tribunal has no precedence is not valid in my view. We should create a new precedent, like in all other cases of such kind. New precedent is now the right proposal. Of course, within the principles of the international criminal law, which are already developed and developed further. So legal precedent, and this legal precedent will strengthen international law, strengthen the basis for the world peace order, because non-aggression or the prohibition of aggression is the basis for the world peace. Also, it is also for a good reason to create such a precedent. And maybe the seventh reason is practicability, because of course there are difficulties to address or to have the presence of high-ranking officials from Russia, and this kind of tribunal in absentia could be a practical solution to achieve the goals of international judiciary without waiting or without doing nothing as an alternative. I will say again, alternative is doing nothing, and doing nothing is the worst case scenario for me. And therefore, of course, trial in absentia is a practical solution. It is in accordance with the principles of development of international law, also international criminal law, and we should pursue this way. Thank you.
Thank you so much. Thank you so much. We have a big list of what we should do. So pick the in absentia format. This is interesting. Okay, let's move further. Why do I like being a moderator? Because I can say anything and no one can take a mic from me. Yeah, that's a good thing. So just as a moderator, with my special rights and authority, I will just reorient our discussion a little bit. Why do we need a tribunal? What do we need it for? For Putin to go to jail, okay? It would be really great for him to go to my Ukrainian jail. I would love to welcome him in Ukrainian jail, but even in Hague, that's a cool thing to do. Let's be cynical. What is the benefit for us, okay? Now he's a powerful president of Russia. He's like, yeah, he's boasting. He has some, I don't know, twins or whatever. Taking his authority away, he will not be a president when he goes to jail, of course, obviously. What is that? It's just, it's a blank, I don't know, it's a moth, a crazy moth. If he's dead, if he's in a jail, the feeling of justice, it will be really good for him to stay there in jail, of course, but not a lot of practical benefit, let's say. And we swiftly move to this topic. A lot of losses and damage we have, a huge amount. What will be the, how will tribunal help us with that, Will it help us in the case of crime of aggression and other criminal proceedings in cases against other Russian leaders? Shall we get money from Russia to compensate the losses and damage? Or it's just a separate track? Where are we there? I will pass the microphone with huge pleasure to Ms. Iryna Mudra, the Deputy Minister of Justice. We have a Chinese wall between us. I'm here just to, I'm helping her. We're fully independent, autonomous. Ms. Iryna, please just comment on that. Okay, thank you. Thank you, Denise. No, unfortunately, the sound is not very good from the microphone. Okay. I'll tell that Ministry of Justice is doing a fantastic job. We can, a round of applause to the Ministry of Justice for that. Thank you. Iryna, thank you, Denise, thank you. First of all, my profound gratitude to participants, to guests, especially to organizers for this wonderful opportunity to take part in this really important discussion on a very important issue. We speak of the restoration of justice because, yes, tribunal, just like the compensatory mechanism, just like the investigation and prosecution of the war criminals, these are three essential components of the comprehensive accountability system. Everyone is talking about that today. And what I really liked, if you take the previous speaker, I liked his statement that justice must be served for victims. So, it's for the sake of victims. It's for those who survived it. So, the procedural aspects of tribunal, what has compensation to do with it? Because we speak of those who survived, those who suffered, those who are affected. Unfortunately, for so many times humanity faced this need to establish war tribunals, International Criminal Court. We heard of Nuremberg Tribunal and other military tribunals, International Tribunal for former Yugoslavia, also Rwanda, Sierra Leone was mentioned as well. All of these took the issue of war crimes, considering the war crimes, crimes against humanity, also the crime of aggression, the genocide crime, all these war crimes. But it revolved around this. But unfortunately, there was no single tribunal where there was raised the issue of reparation and compensation. In none of these. Even the issue of reparation, if we do go back to history, reparation always after the end of the military conflict or the end of the war, and there had to be a party which was defeated, the one who actually got the victory. There had to be like ceasefire agreement or peaceful agreement. The reparations that were paid after the WW2, that issue was discussed during the Potsdam conference, and then there was a decision made that out of $20 billion of reparations after the WW2, they have had to be given to the USSR, the former USSR, and these mostly went to industrial entities. So we don't have any single tribunal after every single word. Nobody spoke there of paying compensations to individual victims of aggression. Yes, Germany, after the verdict was presented at the Nuremberg Tribunal, after it was executed, in 1950s, yes, there was a federal law adopted on compensation. But this law was a targeted law, very targeted law, to cover the needs of specific categories of survivors, like the Jews who suffered from Holocaust, and the labor force that was relocated to Germany. These people had these payments paid for so many years. The compensations were paid. But if you take just the amount of damage, the losses, the scope of losses and damage that our country is having today and every day, and each individual of our country, each citizen, these losses we already calculate in hundreds of billions of dollars. Okay? There won't be any tribunal which will make a decision to compensate those losses, unfortunately. But again, I'm pretty sure that compensation and tribunal, these are intertwined, these are interrelated things, because this is something that will show that justice is there. And only if we hold specific individuals accountable, criminally liable, that is how we can force a country to stick to its international commitments and pay the compensation or reparation. So, what Ukraine is doing and what we insist on in our negotiation with partners, with our allies, what we insist upon, we are discussing this also with those with whom we discuss the tribunal, the modality of the tribunal. We insist for the compensatory mechanism to be established now, here and now, not waiting for the war to be over, not waiting for the tribunal or certain verdicts to come out of that, verdicts for the top military and political leaders of Russian Federation. No, not waiting for any kind of investigation and against war criminals. This will last for years. Ukraine has to start recovering now. Each and every person must get a compensation now to have a chance to continue living, to recover, to restore one's life. That is why Ukraine offers to governments, to partners, the concept of compensatory mechanism. This mechanism consists of three components: International Registry of Losses and Damages, which will be the database. It will accumulate all the information about the damages, the losses, material damage, any other types of damage will be there, and also information will be there about the maximum amount of losses. So, and even now, we drafted the classification of damages, which will be included in that registry. And the victims, the individuals, business, state business, private business. So the damage is inflicted to the state, environmental damage, water resources, land resources, everything will be in the registry. Everything. But the registry itself, it will be useless if we don't have the following steps. We insist, okay, we already have the registry in Dia, where we have more than 470,000 applications, but we need money in order to compensate all that damage. So the second component of this mechanism is the compensatory commission, because unfortunately today there is no judicial entity or institution which gives this fast, effective response on how can we get the compensation from Russia? Nobody gives an answer how to do it. Nobody can. So, the Compensatory Commission, as an administrative body, it will have a simplified and faster procedure to consider all the applications from the registry, and it will award a certain amount to be provided as compensation. We just need a mechanism to enforce the Commission's decision. So what kind of mechanism that can be? Together with the Commission, we have to also establish the compensatory fund. One of the toughest issues, the fund can be established easily. It's not about the structure, how to fill the fund, with what, actually, to have the resources to, let's say, monetize the decision of the Commission. We truly believe that the aggressor state, and we know that it has to pay with its assets, because they committed the crime of aggression. They violated all possible norms of international humanitarian law, international law, human rights violations, UN statute. So Russians committed crime of aggression against the world. They cannot use the privilege given by international law. The sovereign immunity, I speak of the assets of any state. They just can't use it. So that's why we insist that primarily the compensatory fund, it should be filled at the expense of Russian assets. And we work on that together with the states, because many of our allies, almost all of them, they do have international right and national legislation clauses and provisions and guidelines. So there are certain legal barriers when it comes to confiscation of Russian assets, so we offer them legal grounds for it. Yes, Ukraine unfortunately is a driver in that process because we need it the most, and that's true. So in our country, we do, yes, within our jurisdiction, the sovereign assets are taken and Russian oligarchs' assets are taken within Ukraine, and this process still is ongoing. And all the money, all the assets that we get from confiscation, we use it for the defense sector or to recover the economy. So we insist for our partners to use the same way, the same method. So we will offer our partners to, so we already drafted it, and we will offer this international agreement which will allow to establish this commission and compensatory fund to be established. This will be the source of international law which will regulate the issue of confiscating the Russian assets. We are convinced that unless the state, unless its elite, its leadership feels on their own skin, let's say, unless they feel that all their assets, are jeopardized abroad during this war, unless they feel that they may definitely just lose their assets, the business which is still functioning within the aggressor state, this business also should feel that they can lose their assets. Only if they have this fear, and only if we do establish this in international law, if we do that, in future we may minimize the risk of such wars to emerge, because every single war will have a price, a very high price, not just the price paid by the top leaders, but we people who suffer from it, yes, okay, we may have the verdict, but we also need to have a benefit, some financial benefit. And this state will have no immunity abroad. Every oligarch, every person who supports the war financially, with propaganda, any person who is still running the business in the country and filling the aggressor's budget, the one who's feeding the war and fueling the war, if they don't understand that international law not only stipulates but demands for these assets to be transferred to the affected state, without all this they will never think. But if that happens, they will start thinking, should we continue the war? Should we continue the aggression? So this three-component activity, this three-component process, together with the tribunal, with the compensatory mechanism, and also what is important when it comes to investigation of war crimes and ICC, and we know that the first decisions of the ICC are there, all this Altogether, this will give us the justice restored. Otherwise, if we don't restore the justice, if we just don't serve justice, this will become a trigger for those. Many will be tempted in future to have the same wars started. They will understand that there is impunity. And we will have more and more of these tragedies in future. And I hope this won't happen. Thank you. Thank you so much, Miss Iryna. Thank you. Okay, fingers crossed. We do hope that we will not be left without money. And we'll have Russian money. And this is even more pleasant to know. So we're moving forward, and I will turn on the moderator's regime. Okay, we start a little bit later, so we'll have 5 minutes per each panelist. We'll have to, yeah. I will cut my speech as well. But using this pause between the speeches, I used to be like a freshman once. Okay, let us, in the evening, you can just watch the Judgment in Nuremberg movie, 1961. You can watch it on YouTube. I guess it's like free of charge. So you definitely have to watch that. Nominated for Oscar many times, to Oscar is a god. So what am I leading to? There was a wonderful American prosecutor with fantastic speeches. You know, you just have to listen to it. It's worth doing that to understand the role of the judge and the role of the tribunal. And I'm smoothly shifting from American prosecutors to our American colleagues. Okay, we also have online speakers, and right now we'll have David Scheffer with us. His ideas on the tribunal procedure.
Thank you very much. Can everyone hear me?
Yep.
Am I being heard? Yes? Okay, excellent. Thank you very much. It's a great honor to be with you today. And I'm sorry I'm not there in person, but I'm grateful for the capacity of Zoom to bring me into your discussions. And I'm also very honored to be with my colleagues on this panel. I'm going to keep mine, very short to 5 minutes. I'm just going to hit a few key points here. One is that for the special tribunal for the crime of aggression against Ukraine, everyone knows there's still a very hard trail to walk at the UN General Assembly. But it does give us time to consider so many of the aspects of how the tribunal, in fact, would be created in terms of its statutory authority, its governing statute, as well as how the trials, in fact, would be conducted. I happen to have been involved in so many of these efforts in the 1990s. The Yugoslav and Rwanda tribunals, the Special Court for Sierra Leone, the extraordinary chambers in the courts of Cambodia, and of course the International Criminal Court. Let me just share a few points that I've already written about in the September and October 2022 Just Security series on the Special Tribunal, which my colleague Jennifer Trahan was a very key part of, and it continues. The first point that I'd like to bring out is just the general one, that there's no need for there to be a tension between the International Criminal Court and a special tribunal for aggression in terms of how the trials would actually be conducted, in terms of how the investigative efforts of the special tribunal would be undertaken. That can be coordinated with the ICC. They need not be in conflict with each other. In fact, they can actually be working together for the benefit of each institution. And I outline in my October 2022 article what those lines of cooperation could consist of, and how to organize and coordinate the sharing of defendants, the cooperation between the two organizations that I think could be logically arranged through the UN-ICC relationship agreement, since the special tribunal would be, shall we say, a joint venture with the UN established through resolution stimulated by the General Assembly, negotiations by the Secretary General of the UN, and of course with UN participation in the actual conduct of the tribunal and the staffing and the trial work, etc. All of that, I think, can trigger the ICC relationship agreement, and that is good news, because under that relationship agreement, then you can have very constructive coordination between the two bodies. You do not want them to be at war with each other. And finally, on funding, from my experience, which is considerable on the funding spectrum of how to make these tribunals work, I do think there's a valid voluntary funding stream that would be available for the special tribunal without detracting from the funding that is understandably required for the International Criminal Court. And I spell some of that reasoning out in the article. And I also introduce the idea that the special tribunal, under certain circumstances of how we would manage it, could also be the target of a funding stream through a special social bond that perhaps would be guaranteed by some leading OECD states and also private parties as well. Now, I want to just briefly touch on the trials themselves. In terms of, my colleague from Lithuania mentioned the sharing of classified information. We need to pay very close attention to that, because this is a leadership crime, the crime of aggression, which means that the kind of information that will be desired for the trials, whether they be in absentia or in person, is going to probably be fairly sensitive beyond the obvious evidence that aggression has taken place. Mr. Putin self-incriminates himself every day on that count. So all of that evidence is out there in the public. But in terms of actually, using very powerful evidence, you want to be sure that perhaps some classified information could be made available, perhaps as only lead evidence, so that the prosecutor of the special tribunal knows where to look in order to establish his own base of evidence, or under some circumstances that the classified information could be declassified for the purposes of the trial. But all of that needs to be very, very, very carefully worked out with the main suppliers of such classified information. So you're entering a negotiating arena with key governments, and that has to be very, very carefully nurtured. I also think, because of the leadership crime character of the crime of aggression, witness protection will be extremely important for those witnesses who have been close to the levers of power in Moscow, who may be willing to, frankly, take the courageous step of truly cooperating with the special tribunal. Quid pro quo for that true cooperation will be witness protection, and you're going to need the assistance of key governments in order to ensure that that witness protection can be provided, particularly if those individuals have fled Russia and are on the run, essentially. They're going to need a lot of witness protection in order to provide their very valuable evidence to the prosecutor. On outreach, I would just say for the special tribunal, it won't require the kind of special outreach that we struggled with in the 1990s with so many of the other tribunals, because this is such a high-profile endeavor, the special tribunal. Any proceedings of the tribunal will be very well broadcast through journalism, whether it be in social media or the major networks, etc. So it's not a question of getting the word out. It's just a question of making sure that the Ukrainian people, who are the victim population, as well as, I would suggest, the Russian people, understand exactly what is going on in that courtroom. And that can be done through just a strong media blast, which is the advantage of this special tribunal. Now, I want to close with this statement about victim participation. We have had a lot of experience in this in the 1990s, particularly with the extraordinary chambers in the courts of Cambodia, but also with the creation of the International Criminal Court and the rights of victims before the ICC. So I've been knee-deep in this, and I just want to put a word of caution. Because the Ukrainian people have been so egregiously assaulted on a daily basis under both the crime of aggression and the other atrocity crimes of war crimes, crimes against humanity, and genocide, there is a huge appetite among the victim population of Ukraine to be part of this process. Understood, we get it. There's no disagreement about that. The problem is you have to be very, very careful about what you establish as victim participation, because our experience, particularly with the extraordinary chambers in the courts of Cambodia, is that victim participation in the courtroom can prove to be a retardant to getting the trial accomplished. It can be a huge delay in actually achieving justice in the courtroom. Even the selection of who are the eligible victims to be party to the trial itself bogged down the Cambodia Tribunal for years, because the investigating judges had to determine who would be the eligible victims. Meanwhile, our defendants died. So you need to be very careful about that. Do not overreach with victim participation. You know, one thing that we did in Cambodia was we made sure that hundreds of Cambodians attended the trial every single day. That auditorium of 340 seats or so was filled almost every single day. And that meant that at the end of the day, I think about 240 or 50,000 Cambodians had actually sat in the courtroom and watched their former leaders under Pol Pot being prosecuted. That was one way for the victims to clearly, have a close in the room presence. And I would strongly recommend that the special tribunal, if it's set, if and when it's set up, and I'm very hopeful it will be, if it's located in The Hague, which it probably would be, there be some consideration for some of the proceedings of the special tribunal to be held in Ukraine, so that the Ukrainian people can be in the audience of the courtroom to witness it. And my final point on reparations, which I know was brought forward, that's very much a state responsibility issue. It will involve all sorts of negotiations, et cetera, in the future. But I would say that if oligarchs are brought to trial before the special tribunal for their participation in the crime of aggression, remember, the oligarch's assets might be able to be valid reparations in a criminal trial of those individuals. If it's Putin, his assets, of course, would have to be identified. That's a very, very tough pull. But again, that creates a very large responsibility on the part of the special tribunal to nail down with investigative skill where those reparations are, and are they literally attached to that individual who is on trial. So I'll close there. Thank you very much.
Дякую дуже.
I thank the speaker. We have heard a number of interesting procedural aspects, and I could absolutely agree that it would be absolutely difficult to engage all the affected population, and whether we should be selecting people for the or the affected population for the court hearing, and how do they do that considering the scale of aggression, the scale of the crimes committed. But let's move on, and now I'd like to pass the floor to my colleague. She's here online, Oksana. Blazhivska. She's the member of the High Council of Justice, and she might also share her thoughts and experience. Already we had a number of cases considered in Ukraine, including cases in absentia, and not only the executive power and the office of the president thought about the future tribunal. So Oksana, please, you have the floor. thank for the possibility to speak, and I want to thank everyone still in the room. This is absolute courage, particularly for the young audience. I'd like to thank the organizers for inviting me to join this important discussion on the establishment of a special tribunal. I think now we have no doubts that such a tribunal has to take place. It has to be established. I heard some very interesting statements and briefings by the national and international experts. They talked about the admissibility or inadmissibility of certain models for the special tribunal. We talked about what can be faster, and for us, the key aspect is that we're discussing the establishment of a tribunal in a country which is still at war. I mean, we have parents, grandparents. I think they've never thought that they would once again face the bitterness of the war and the blood that we are feeling because of Russian aggression. Every day we are registering the crimes they're committing, and as a representative of the High Council of Justice, I would like to inform you on the list of the crimes they've committed, some new crimes that they've committed just recently. The president of the aggressor state creates quasi-courts in Zaporizhzhia, Luhanska, and Donetsk region, and he appoints 222 judges. Whether it's a lot, it is a lot, and for us, as the High Council of Justice, we have this question of running the analysis. Who are those people? Whether these are the former judges that left the service, we don't know their full list yet, or maybe they have not retired from Ukrainian system. That means that the number of crimes increases. The territory of the crime also increases. It runs outside of certain borders. It goes to new levels, and the issue of the establishment of a tribunal has to be resolved as ASAP, because there's a major question involved. We need to settle this problem as soon as possible, and I hope that the establishment of the tribunal shall be admissible and shall be understandable for the whole world, which, just as Ukraine is expecting for the tribunal to be established. And the tribunal is being discussed in many formats. The history knows the examples of many tribunals, and the first tribunal, well, we thought it would be the first and the last. That was the Nuremberg Tribunal. Then we saw a series of tribunals that were established, and while analyzing their actions, we got an understanding about what sort of tribunal are we willing to see, what should be the statute, what's going to be the contents of the statute that shall be guiding for the special tribunal. And there is a key question also. There has to be a consideration of different models for the tribunal. Today we've heard 3 models of the tribunal, but still the most important issue that has to be raised is the issue of temporary, territorial and subject jurisdictions, more specifically about the temporal jurisdiction, because we shouldn't talk only about the time starting from 2022. We have to cover everything that has happened after 2014. This is very important for every Ukrainian and the world. The next question, which is more dealing with the procedural aspects, and this is something we have to discuss now, because we are talking about models right now. We don't know what's going to be the final model or the model of the statute, since this is only a platform for discussion. But it has to cover the roles for the procedure of evidences, the admissibility of the evidences. We know that there is an international prosecution center for the crime of aggression against Ukraine, and it works on the establishment on gathering the evidences and investigating the crimes committed. It's important what evidences shall be gathered, how they will be preserved and provided and transferred. This procedure is very important. The next matter that I believe should be considered, it also subject to a discussion. This is the matter, the rights of the accused, whether it has to be present or in absentia. Now, these are the questions they should be considered and mentioned in the statute. The next question that's about the protection of the witnesses, the protection of the victims, because we don't know what to expect from the aggressor state now. We have to understand the types of the punishment, the procedure, and the designation, but the key aspect, I think, has to be a form of the decision, what's going to be in the decision of this tribunal, in order to make sure that this decision would be doubtless. This is the precedent, and it has to become a red line that nobody will ever kind of cross, so that we wouldn't have to create the tribunals all so often, and because we are a civilized world. The next questions that I think should be considered on a procedural matter, this is the question related to the fact what has to be provided in the list of rights to fair trial. The next aspect, it's not only the transfer of evidences, but also the development of the procedures for witness protection. We have to point to the fact that what this will take into consideration in terms of the time, so that it wouldn't be the case that certain evidence has expired. I think this is important, and surely this statute has to take into consideration the issues we've raised today, and we're not going to touch upon the issue of immunity. And I'd like to compliment Ms. Iryna. This is the most important question, the question of consistency, because holding accountable, that's one component, and compensation reimbursement, it's another component, and that's a prerequisite for the revival of our economy. Now, going back to those facts, and I agree with Iryna, but still I would like to say that whenever we're talking about the court decisions, if the individuals will go to court, then the court decisions has to be consistent for making sure they would be admissible later on, and they could be exercised in future. And today we also need to discuss some models of the decisions, and we have to understand who is going to assess the damage dealt to the physical and legal entity. We understand that it could be not always compensated for every legal and personal entity, because this money are very significant, and I believe that the world will try to overcome what has happened. Therefore, I think these are the questions to the consistent models and solutions. We're talking about the tribunal decision. As for the compensation, I think it's an important matter that has to be discussed in the frames of the procedure. It's also efficient to point to a number of other aspects, and we've heard today an aspect raised by the moderator: who's going to be there, who will be the prosecutor, who will be the judge, and who will be part of the justices. So, because these are also important questions, because they will have an impact on the tribunal. We have to understand that the tribunal is something that is necessary, but it will not be the court, it will not be the institution that shall be somehow posing obstacles for the ICC. They shall be supporting one another. So if they will be complementing one another truly, then we will have a model, we will have the protection, and to see the model of the punishment of those guilty. Those guilty among the aggressor state, and we know that There's some of the perpetrators in Belarus, because their heads of state and government are responsible for that, even though it would be hard to prove that. And I think these aspects has to take the priority negotiation. If we'll have an understanding on the answers to the questions, I think we'll get some positive answer. We'll have a rapid victory, because the establishment of the court will serve as a red marker that nobody will ever attempt to cross.
So thank you for your attention. Thank you so much, Ms. Oksana. Thank you. And we have to move a little bit faster because we have like a little time, so we started later. And we are out of schedule already. Okay, so, okay, online. Jennifer Trahan. Clinical professor at NYU Center for Global Affairs. Okay, Jennifer, are you there?
We don't hear you. Okay, поки пані Jennifer.
So, Ms. Jennifer.
Now we hear you.
Good. First, let me say how deeply honored I am to participate in this crucially important discussion. How the trials will be implemented is critically important. I believe what is required is an international tribunal. That is the way to avoid head of state and other immunities so that we do not bar the prosecution of top-level leaders. It would also be the mechanism to provide the greatest legitimacy. Considering that the tribunal's establishment could potentially try the very highest level leaders, fairness and the appearance of fairness will be critical. With a tribunal structured well and trials done right, this could be this century's Nuremberg moment, but these must be fair trials. If the tribunal is structured in an agreement between the UN and Ukraine, Ukraine will make the decisions in how to structure it, but I have some ideas I'd like to put forward. We were asked about the composition of the bench, the judges. So one of the advantages of a fully international tribunal is we can certainly have judges from around the globe. So this has certain advantages. It's very hard to argue when you have judges from many, many countries that there's any kind of bias involved. And I know I'm talking to a Ukrainian audience, so my next comment may not be that well received, and I do not mean any discourtesy to the Ukrainian judiciary, but detractors could easily discredit Ukrainian judges as lacking in impartiality. So this needs to be a consideration. If you have the tribunal through the United Nations, it would be the UN Secretary General who selects the judges, and they could be a fully international panel. That would ensure the highest degree of impartiality and best reflect the international nature of the crime as one against the global order. We were also asked about trials in absentia. I know this is a difficult question, but I don't think we should worry initially too much about how arrest warrants will be executed. In the long scheme of history, justice does come. When the Yugoslav tribunal was being established, we had no idea how Slobodan Milosevic would end up there, or the same was true of the Sierra Leone Special Court, yet Liberian former President Charles Taylor did end up there. The alternative, if we do not have trials in absentia, is not doing nothing. There is much that needs to be done to establish this tribunal. We should move ahead. Another speaker said, as soon as possible. I completely agree. First, it takes a while for all the agreements and to create the tribunal. But there is much that can be done in the absence of accused. Firstly, even the issuance of high-level warrants is an extremely powerful statement, and that can move ahead. It's also been referenced, there is a bit of a ground between trials in absentia and no trials in absentia. So in between, there is something called confirmation of the charges, and evidence can be put in the record at that stage. Also, reference was made to the Article 61 procedures of the Yugoslav Tribunal, where evidence could be preserved. So initial witnesses against Karadzic and Mladic put in their testimony years before those two were apprehended. So there is much that can be done. Most of our international and hybrid tribunals have rejected trials in absentia. There are many countries around the globe that would see that as a fair trial violation. Now, I know there are some countries that accept trials in absentia, and I know Ukraine is one. But in the international stage, if you're going to carry the greatest legitimacy, I believe you do not have trials in absentia. I also want to stress the importance of using the definition that we have of the crime of aggression found in Article 8 bis of the International Criminal Court's Rome Statute. That was the product of decades-long negotiations. I was part of the negotiations, and I can tell you the Russian delegate was in the room and agreed with the definition. It has been accepted by all the states parties of the International Criminal Court and represents customary international law. It would provide a strong basis to proceed on. Very briefly, I believe the trial should be in The Hague, the tribunal. This would facilitate cooperation and coordination with the International Criminal Court and Prosecutor's Office. This would be a narrowly focused tribunal focusing only on the crime of aggression, which is a leadership crime, so only focused on top-level leaders. The jurisdiction, the crime is partly occurring on the territory of Ukraine, so there is jurisdiction. If you word it that way, that would pick up aggression, whether it is Russian aggression or the role of Belarus in facilitating the aggression. Temporal jurisdiction will be an issue to negotiate. I know that Ukrainians firmly believe this all started in 2014, and I solely respect that. If you have temporal jurisdiction in 2022, that starting in 2022, that would make a more narrow focus. I think this will be ultimately an issue to be negotiated. I want to end with simply stressing the importance of fair trials. We by now have a long list of fair trial protections, and these must be utilized and applied by any tribunal. This is a question of legitimacy and history. This is making history, and it must be done right. I will end with a quote from Judge Pavel Dolenk, writing in the Rwanda Tribunal in a separate opinion in the judgment in the Ntagarura case. On fair trials, he said, "I understand that the importance of fair trials may appear pale in comparison to the gravity of the crimes that occurred. However, it is only through a fair trial that we can achieve any lasting justice." Justice Murphy of the US Supreme Court explained nearly 60 years ago, "If we are ever to develop an orderly international community based upon a recognition of human dignity, it is of the utmost importance that the necessary punishment of those guilty of atrocities be as free as possible from the ugly stigma of revenge and vindictiveness. Justice must be tempered by compassion rather than vengeance. In this first case involving the momentous problem ever to reach a court of trying a highest level enemy leader, we must insist within the confines of justice on the proper application of fair trials in the trial of our enemy commander. Otherwise, stark retribution will be free to masquerade in a cloak of false legalism, and the hatred and cynicism engendered by that retribution will supplant the great ideals to which this nation is dedicated. So I simply want to stress we're at a critical moment. It must move forward. We also must move forward quickly because sometimes the spotlight of the international community passes. If you get too far away from the critical moment, you lose the attention of states. So there is still a ways to go in convincing states at the UN to vote for this tribunal, and this work must be done to convince states from all regions of the globe, and it's particularly those Central and South America and African states that right now, they see this as Europe's problem. They see this as Ukraine's problem. So there is still much work that must be done to convince them that when a powerful country feels absolutely free to invade its neighbor, none of the countries of the globe are safe. And this message still needs to get out there. Thank you.
Дякую.
Thank you so much. No jokes, organizers say that for each minute of delay, I will pay for the rent of this room. Okay, I personally will. Now, the next offline guest, Mathilde. Philippe Gayso, please, from Université Jean Moulin, Lyon. Please.
Yeah. First, I would say maybe hello everybody. Thank you for the organizers for this wonderful event and very important event on a very important matter. I will say a few words first so that you know who I am and why I came from France in a long trip, she knows, to speak to you today. I am an academic, specialist in head of state's responsibility for international crimes and the crime of aggression in particular. In 2022, if I very quickly joined the initiative of Philipson and Gordon Brown as Harif Abram, who is here, it was in particular to bring Vladimir Putin and his Belarusian counterparts before the future special court. Because the crime of aggression committed by Russia against Ukraine is manifest. And also because that's my area of expertise, I knew since the beginning that was possible to put Putin in a trial. But what I'm going to say also applies to all the top leaders, accomplices of Vladimir Putin, okay? I'm concentrate of Vladimir Putin, but I know that what I say is also for his accomplices. Thanks to the media campaign around a book that I wrote in France for French speakers, the idea of setting up a tribunal, which was so controversial in France at the beginning, at the outset, is spreading. Even among the academics, my colleagues were very, very against this idea. So I'm thanks to Philipson who told me to write this book. Because now in France, it's like an idea very common to say that there will be a special court to judge, in particular, Vladimir Putin. And now we are doing the same in Belgium, in French-speaking Canada, and the next step is to convince Africa and French-speaking Africa countries. That's what we will do with this book. The name of the book for the French-speaking, it's not for you, but French speakers. The name of the book is Are We Able to Judge Putin? And I can spoil it for you because you will never read it, it's in French. I can spoil, we can judge him, we must judge him, and I explain how. So a lot of things have been said, and I will try to emphasize a very important matter after the detail of the procedure rules. This important matter is the same that the previous speaker, is the procedural guarantees. Let me try to put it more clearly. Usually, when a tribunal is set up, once the question of its form has been settled, procedural issues become particularly important, because these aspects which seems very technical, I know, are in fact the guarantee that the tribunal setup will not be challenged, will not be criticized. So what we are talking about since the beginning of this panel, when we think about procedural aspects, is the future of the tribunal. Why are procedural aspects so important? You know, one day, the mother of a little Ukrainian victim who was in my town, in Lyon, in France, asked me, what difference will it make to me, to my daughter and me, if Putin is put on trial? And what she said is not the one who used his hand or his body to kill, to rape, to hurt, to humiliate. It's not him. The people who hurt my daughter, the man who hurt my daughter, is not Vladimir Putin. So why do you absolutely want to judge him? In a way, she was right, but it's a question of justice, and the question of the form of the court and of immunity that we have seen this morning are designed to make justice possible. But judging Vladimir Putin and his accomplices is also a question of truth. After the international crime itself, what hurts the victims the most is negationism. And that is the great Ukrainian writer, Victoria Amelina, to whom I would like to pay a tribute here, by quoting one of her verses, one of her poems. What she wrote is, "Call me a liar, because there is no justice." What she wrote in this wonderful poem about women and war shows that the problem is that sometimes some people like to call victims liars. And if we don't have procedure, a perfect procedure for the next special court, a lot of victims could be called liars. So those procedures aspects are very important. In fact, they are not just technical problems for lawyers. This is for the victim also. The problem is that the people who deny that crimes exist also deny that the court is a real court. So that's exactly what procedure is for, to guarantee that the truth will not be challenged, that no one has the right to call a victim a liar. Talking about procedure is therefore particularly important for the victims, for Ukraine, and for the collective memory of the world, even Africa. That's why we want to convince them. To avoid the negationism, what is incredible is that by establishing the future tribunal, we have the opportunity to show that justice is not the justice of the victory. It's not the justice of the one who is winning the war. Even when Ukraine will have won the war, I know it will, but it's not because it will have won the war that Putin and the others will be judged. It's to allow the leaders of a top 5 country on the Security Council to be judged when they initiate a war, not against the winner, but the Ukraine will be the winner, but it's not the problem. The problem is that they initiate a war against a country they imagine to be less powerful. In short, international criminal justice will no longer be a justice of the victors, but a justice that gives smaller countries a chance to defend themselves legally against the major geopolitical powers. So we have the chance to change the international criminal law with this special court. What should be done from a procedural point of view? The future tribunal, which I think, like many speakers before me, does not necessarily have to be set up by the Security Council, and that I think also that under international law, immunity does not apply to the crime of aggression against Ukraine, but I let it for this morning discussion. Thanks to every speaker before me for putting this out so clearly. But what I want to say, it's an ad hoc international tribunal are international tribunals created for a particular context. So they therefore differ from the so-called permanent courts and have their own procedure. The advantage is that we already have experience, particularly with the procedures of the 2 international criminal tribunals of the 90s and the ICC. But what is very important is what the previous person said, is that we have to respect the guarantee of a good trial. I know that some of you have already attended or taken part in trials of head of state. Have you noticed that, and Putin will do the same, have you noticed that when a head of state is judged, he's always doing the same. He always has the same attitude. Thanks to Milosevic, thanks to Iryna, thanks even to Ceausescu, they always do the same. So first, what they do, first of all, they contest the validity of the court that is judging them. So Putin will do the same. And after, they do something. I don't know if you noticed. They're always watching their watch, have a look at their watch, like this. And why are they doing that? Because they are playing with time. They try to avoid the process, the verdict, by playing with time. And while watching their watch, they try to show that they will play with the time. And we must avoid, by the procedure, this kind of tactic. So I'm not in favor in absentia process, because I know that Putin will be arrested, because I have to go further. I won't say how, but there is 3 solutions to arrest Putin, and I know it's possible. So I think if we organize an in absentia trial, it's to say that he won't be arrested. He can be arrested. Everybody said it was not possible for Milosevic to be arrested by its own police. He has been arrested by its own police. Everybody says before a trial that arrested the head of state, it's not possible. It is possible. It has been made. It will be made again. So that's why I'm not in favor of absentia trial. The procedure applied, whatever it may be, must avoid challenging the validity of the court. Think of Iryna being dragged to the dock and closing his eyes. Have you seen the Iryna court? The case? I don't know if you know, but he closed his eyes to avoid watching the judges, to show that it was not in favor of the court. But sometimes he was opening his eyes like this to watch a little bit. But he wanted to contest. So just think what Vladimir Putin or Lukashenko and the others would do when they are in the dock. To avoid this attitude, the future court will obviously respect the law. This future tribunal will offer guarantees of independence of judges, impartiality, equality of arms. From the point of view of victims, witnesses, interveners, and the accused themselves, the fundamental rights must be respected. In particular, even Vladimir Putin, if he's alive at this moment, will be deemed innocent until the verdict has been given. He will be considered as innocent. But when the verdict will be given, it will be the proof for eternity that is guilty of the crime of aggression. So the Nuremberg trial showed that this pressure that we give to the head of state facilitate betrayal between the accused. And I hope that we will soon have an arrest warrant to put the pressure of Vladimir Putin and to put the pressure of all the people around Vladimir Putin to put them, to force them to betray him and give the proof to the court, as the Nazis did for Nuremberg. They betrayed each other's, and they gave the proof. I'm sure we can do exactly the same for Vladimir Putin. Another procedural guarantee is the right to appeal. So we can imagine that if there are residual functions to be carried out at the end of the future tribunal's mandate, it will be taken over by an international mechanism called upon to carry out the residual functions of the criminal tribunal. And I don't think we need a Security Council resolution, only an Assembly General resolution, but I will pass also. So my second point is related to the first. There is another procedural guarantee, the so-called reasonable time requirement. You know, the one they are playing with, where they are watching their watches. So forgive my frankness, but to ask for an international tribunal is also to play for time, ask for an hybrid tribunal. is also playing with time. Is also thinking that it will last a long time. Because how can you imagine to, just to change the Ukrainian constitution during the state of emergency is not possible. So if we have to wait, it's just gaining time and losing for us time. So we have to have an international tribunal, not an hybrid one, because if we ask for an hybrid tribunal, we are playing the same game that Vladimir Putin and other head of states. So really, we have to have an international tribunal. I'm going to finish by continuing my tribute to Victoria Amelina, whom I think very highly today. Just as I think very highly of all the victims of Russian aggression when I campaign like you to establish this tribunal. And this is what Victoria also wrote. She wrote, Ukraine's dead are my dead. Its survivors are my sisters. And I will add, the dead are my dead too, and are all part of my family. They are just not my sister, but my brothers, my son, my daughters. We support you and in your fight for justice, and procedural guarantees will be particularly important for this. So, Slava Ukrainia, maybe, and thank you.
We thank you for this wonderful briefing. Just to complement the arrest warrant creates the feeling of pressure upon the Russians. The only thing is that I know how they leave, and I believe that this kind of pressure it creates, but when they drink vodka, they sort of feel relieved. So we need to keep on more and more pressure. You know, remember we had a film like an old Soviet movie, who's gonna work in prison, who's gonna work somewhere else. And we have weapons by Western partners, humanitarian aid, Western partners, millions of others, refugees and hostages. They are done by partners with the Ministry of Foreign Affairs. That's why I'd like to pass the floor to Oksana Zolotaryova from the Ministry of Foreign Affairs. I thank you. Unfortunately, none of us can use microphone, so I have to apologize for a small delay. I thank for the warm words, welcoming words for the Ministry of Foreign Affairs. Since there's so many young people here, I advise you to join our team. You can write an email with your CV, with your motivation letter. We'll be happy to see you at least for an internship procedure, so that you could take a look from the inside on how those tribunals are being created. Because this is just, only a small share of the work which is done in order to come up with some sort of a product. So my email is 72@gov.ua. We'd be happy to join you in the team, so please spread this information among your friends. As for the procedural matters, these aspects were truly debated. We have a number of challenges to be resolved by the team of the MFA and the team of Ministry of Justice and the Regional Prosecutor's Office in order to make sure that this special tribunal to be effective, productive, and rapid sort of body that would allow us to achieve a result favorable to us, which is to see Putin behind the grades. That would compensate all the damages inflicted upon the Ukrainians. Now, for this to happen, we need to do some work, and we've already done some preliminary work. We've outlined some of the elements that shall be common for any type of the tribunal. It could be either international or internationalized, or maybe some other type. The first path has already been done, the first element has been done. This is the establishment of the Center for the Prosecution for the Crime of Aggression that has been recently started or opened in Hague. Now, this center will play a very important function as to gather the evidences, and at this stage, this is the key element that promotes the cooperation between the investigation, the crime of aggression, the investigation that is run by the ICC, and the investigation which is currently provided by the national prosecutors' offices of different countries who have established this joint investigation team and that are running those investigations jointly. Now, this ICPA, it will allow to store the evidences in a quality manner, because we understand that storing evidences in Ukraine is not the wisest solution, because considering the amount of missiles landed upon the territory of Ukraine, those evidences could be easily destroyed. This office, the ICPA, it allows to preserve all those evidences as well as to ensure their properly exchange is shared in between of the tribunal and other entities. What is important is to have the cooperation between the tribunal, ICC, and the national jurisdictions. Now, this is a matter not only related in sharing the evidences, just not to go deep into detail. The key matter is all about the terms for the punishment and the location where the imprisonment will take place. Because surely there will be a punishment. This is something we need to coordinate in between ourselves, to coordinate inside the international community before the start of the work of the tribunal. An important element of the procedure is the fulfillment of requests for international legal assistance. We're talking about the requests inside the civilized world, as well as the requests that might be coming and that will be sent to the law enforcement agencies of Belarus and Russia. We're talking about the question of the protection of witnesses. We already talked about this, and the experience of international tribunals proves that the witnesses have to be protected. Already there is an understanding on which advantages and disadvantages are there for different types of mechanisms. So now the time has come to update all those procedures with due account to the valid practices. The important matter, which has to be taken into account when it goes to special tribunal, because everyone thinks that, well, the decision is made and then the tribunal is over. But then a question, what to do with the archive, where to store this archive, how to store this archive, who's going to store that, who will get access to that. These are some procedural rules. One more thing that I wanted to mention, a brief one, that we need to think of. This is the matter of ensuring that the defendants have the right for defense. How the future tribunal will ensure that someone will play the role of the devil's lawyer, because the right for a defense is one of the major rights. I mean, are we going to appoint special lawyers, as this is done in the ICC, or like it was in Hague, in the court of Hague, when three of the defendants, or of the accused ones, had no lawyers and they were not represented by anyone. And this is important because when the time has come, we would need to have answers for all those questions. Thank you. I thank Oksana. It's already the second recommendation we have from the lawyer of the devil's lawyer. So I was supposed to draw some conclusions in the end of the panel, but I'm not going to do that because I didn't do the good work. Because let me have the floor to Stefan Holbe from Köln. Stefan, you have 2 minutes.
Thank you very much for giving me so much time for my presentation. Therefore, I cut my presentation short. I start with, first of all, thanking you for the invitation, though it is a short presentation here. Secondly, I will express my greatest sympathy with the Ukrainian people for what they are suffering, and we see the daily suffering. And third, I want to convey the good message that in the short time since the Russian aggression, I have already brought one student from Ukraine to a doctorate degree, which I think is a wonderful thing, and she's now hopefully working in Kiev. I skip half of my presentation that looks into the history of modern international criminal law. I mean, with this, the criminal law after Napoleon. And so it starts, of course, then with the victory instigations of the Nuremberg trial and the Far East trial of the two trials, the tribunals set up by the Security Council and the other ones, and come up with, not, Mr. Chairman, I'm sorry, with 3 questions, but I come up with 5 questions. And I want to then try to answer those 5 questions. First, to which legal basis is the tribunal legitimized to act? 2, who is going to be sued? All presumed war criminals or only a group of them, for example, the commanders? Moreover, 3, it must be decided who shall be allowed to sit as judge. Here the question of the character of the tribunal as an international, national, or hybrid tribunal is crucial. 4, finally, it must be decided which crime shall be adjudicated, only capital crimes, the ones as listed in the Rome Statute on the International Criminal Court of 1998, or also other crimes. And 5, which role shall Ukraine law play? And the following I shall try to answer these questions. The legal basis can't be a resolution of the Security Council because of Russia's presence in the Security Council. Various opportunities have been considered. Perhaps a resolution of the General Assembly of the United Nations adopted with a considerable majority, including many important countries, Japan, Brazil, South Africa, Nigeria, Australia, Argentina, the United Kingdom, France, Germany, Poland, etc., and China abstaining would be a good basis. Alternatively, one could consider declarations of the national parliaments of the UN members declaring that they wish to get a tribunal established. Who shall be sued? This is a very difficult question. Arguably, it should be singled out from the beginning only such crimes which one will be able to prove. Therefore, it is more important to look at possible successes of the trials in terms of the condemnation of the presumed war criminals than to try hard, but in the end without success, to accuse everybody and at all levels who presumably was involved. This is, of course, the Ukrainian people must be asked whether this is considered to be acceptable. Third, about the composition of the tribunal. Perhaps a mix of both options that have already been tried should be taken. Half of the tribunals be composed by experienced judges and other capable personnel from the area of international criminal law, and half of the tribunals being composed of nationals of Ukraine. It is believed that the massiveness of the crimes against the Ukrainian population justifies a strong participation by Ukrainian people. I therefore plead for a hybrid tribunal. 4, which crimes should be adjudicated? Although the idea of retaliation for what had happened could probably lead to an all-encompassing trial, wisdom should govern and allow for a concentration on the most important crimes along the scale of the Rome Statute, the International Criminal Court, just as genocide, crimes against humanity, war crimes, and of course the crime of aggression. The fact that it may be difficult to bring all presumed Russian war criminals to trial is no reason not to present all charges against them. Finally, shall at all, and if so, and how far shall Ukraine criminal law be applicable to the charges? But I think here international criminal law is so far developed that it incorporates basically, after my study, basically all what also Ukraine criminal law would incorporate. I want to close with a quote or with a memory to the late Judge Bergenthal, to whom I will speak in whose memory as president of the German Society of International Law. Judge Bergenthal, who fled from Auschwitz and Sachsenhausen to concentration camps, came up in his wonderful book, A Lucky Child, as a person who could still live after the horror. They think, after all, where I have so much understanding, you, my Ukrainian friends, this is also important to look for the future. Thank you very much, Mr. President. Thank you very much for your attention. Thank you.
Дякую. Ну,
Thank you so much. The moderator failed the task, but panelists performed very successfully, very well. Thank you so much. We lawyers have a flaw. We really love listening to our voices. That's why we create these delays, but still, thank you, ladies and gentlemen. Dennis, thank you so much. It doesn't matter how better moderator you are, but still we disagree. Okay, so we're grateful to speakers.
To our invited online speakers. Я вже бачу по вашій активності.
I can see that you understand that we have the coffee break. Okay. Let us respect each other. 10 minutes for a small reload. And I really am looking forward to get you back because we have the fourth panel. Very informative panel.